If you've been following the Blake Lively versus Justin Baldoni and Wayfarer case, you know that there's a separate but related case called Jones versus Abel, where the Wayfarer parties and Jennifer Abel, who is the current publicist for Justin Baldoni, they're being sued by Stephanie Jones, the former publicist for Justin Baldoni and Wayfarer, and the former employer of Jennifer Abel. In that lawsuit, Wayfarer Studios, which is Justin Baldoni's company, made counterclaims against Stephanie Jones. Stephanie Jones, of course, filed a motion to dismiss those claims, and the judge has now given a ruling on that. I'm not going to read through the whole ruling, but I am going to give a quick breakdown of the main points here because I'm in the middle of my workday. And also you can see Butters taking a nap behind me, so he's a little bored. So he doesn't want me to sit here for too long. So the judges granted the motion to dismiss in part and denied the motion to dismiss in the part. So let's look at what survived and what didn't. So if we jump down to the conclusion, it says counts 1 and 2 of the counterclaims are dismissed with prejudice, meaning they cannot amend those claims. The motions to dismiss counts 3 and 4 are denied. So counts 3 and 4 have survived. Counts 1 and 2 are thrown out. So in the discussion part of this ruling, the judge is talking about breach of contract here. It says Wayfarer alleges 2 distinct theories of breach of contract. First was that Jones breached their agreement by failing to abide by the confidentiality provision. And then second, that she breached their agreement by failing to perform services in a professional manner. So when we get to breach of confidentiality and we read what he's writing here, we have to remember that Wayfarer Studios is a separate party than Jennifer Abel in this Jones case. When we talk about the Wayfarer parties in the Lively case, that includes like the publicist, Melissa Nathan, Jennifer Abel, and they're kind of grouped in with Justin Baldoni and Wayfarer Studios, Jamie Heath, Steve Sarowitz. But in this case that we're looking at right now, and in relation to this ruling, we are only talking about the studio and the studio's claims against Stephanie Jones. So my understanding of some of what the judge is saying here is that some of the information Wayfarer alleges was leaked was not protected under the confidentiality clause. Like it doesn't fit the definition of confidential information by their contract. The judge says that Wayfarer's claim fails because they don't allege any information that was protected by that provision was improperly disclosed by the Jones parties. In order for something to be considered confidential information, it has to be disclosed by the Wayfarer parties to JonesWorks. The Wayfarer parties relied primarily on allegations with respect to messages taken from Jennifer Abel's iPhone that were shared with the Lively parties and the media. So to my understanding here, the problem is that this was Jennifer Abel's information off of Jennifer Abel's iPhone that they leaked to Blake Lively. This was not information that the Wayfarer parties directly provided to JonesWorks and then JonesWorks leaked it. So because of the language in the contract, this wouldn't be considered Wayfarer's confidential information. It would be considered Jennifer Abel's. The judge says those messages were Abel's private communications with individuals in the Wayfarer circle and were not communications provided to JonesWorks by Wayfarer. So the overarching issue here is just that it was not their information to be leaked. It was someone else's, in this case, Jennifer Abel's. Then we get to the breach of professional manner provision. It says in its second counterclaim, Wayfarer alleges the Jones parties breached the obligation to provide services in a professional manner and in accordance with the goals mutually established by Wayfarer and Jones. Wayfarer argued that Jones was in Europe and largely incommunicado during a critical time, that she contacted a Daily Mail reporter about a story they had published about Baldoni and Lively in violation of their directive. And after Wayfarer instructed Jones to cease all activities on behalf of Wayfarer and Baldoni, Jones insisted that she could do whatever she wants to clear her name and emailed a number of key Sony executives working on the film, placing all blame on her team. The Jones parties argue that the complaint does not allege facts that would support the claim that they acted in an unprofessional manner or failed to follow mutually established goals. So from a personal standpoint, I think any prospective client or like a layperson, like that's what I'm doing, I'm just observing here. From my opinion, I would look at that kind of behavior from Stephanie Jones and think, wow, God, yes, that's unprofessional. But the legal standard is going to be different. So the judge has to kind of scrutinize the language in the contract. And it says JonesWorks did not have a freestanding obligation under the agreement to act in a professional manner in all respects. It had an obligation to act in a professional manner in connection with the required services. For example, to provide services in a professional manner. Okay. So the judge says that the agreement defines the services, the relevant services, as strategic communications services. And there are 5 categories lined out in their contract. For example, they have managing media and press communications and advising on marketing and campaign strategies. He says that the services in the contract between Wayfarer and JonesWorks did not include crisis management. He says the agreement also does not specify a particular employee of JonesWorks who is to devote their time and attention to provide services for Wayfarer. So it doesn't say it specifically had to be Stephanie Jones. So the judge says per the contract, JonesWorks itself, and not Jones specifically, was required to provide each of the services in a professional manner. So as long as JonesWorks, the company, provided the services themselves, it would have satisfied the covenant, even if Stephanie Jones herself fell short. So he says the counterclaims don't identify any respect in which JonesWorks failed to perform the promised services in a professional manner. And while they made allegations against Jones personally, Jones herself was not required by the JonesWorks agreement to devote any of her time personally and her attention personally to Wayfarer, as long as the company itself was performing the services. So this does not mean that Stephanie Jones didn't act like an unprofessional loose cannon, because you can kind of tell that she did, based on the depositions and the discovery that's come out. However, what he's saying here is that, based upon the law and the contract that they have, the company itself was still fulfilling the services that they needed to fulfill in a professional manner. So it doesn't matter if Stephanie Jones, the individual, kind of took a spiral off the deep end there, as long as the company was still fulfilling its contractual obligations with their other employees, which at the time, at least at some points in time, included Jennifer Abel. So the judge made a note here about this claim that Stephanie Jones violated an instruction of Wayfarer by contacting a Daily Mail reporter. And the judge says the contract required JonesWorks to act in accordance with the parties' mutually established goals, not in accordance with Wayfarer's unilaterally set directives. And I'm reading that and I'm thinking, okay, maybe that's true in regards to the language in the contract. And maybe the judge has to act on that. But I think that's just a bunch of bullshit. Everybody knows if the client tells you not to do something, you should not do it. But yes, I understand that the court has to act on the language in the contract. And frankly, I disagree that acting against Wayfarer's wishes in that scenario was, in accordance with the parties' mutually established goals. I just disagree with this in general. He says, moreover, the allegations are telling for what they admit. Wayfarer alleges it instructed Jones not to talk to the press, but the counterclaims do not allege that she did talk to the press. What do you mean? To the contrary, it states merely that Jones left word with the reporter, not that they were ever in direct communication about the matter. That's fucking stupid. That's just stupid. It's nitpicky and it's stupid. And yes, I understand that my personal opinion does not, outweigh the law and how these things have to be interpreted, but it's still really stupid. There is no allegation that Wayfarer's instruction about talking to the press was ignored. There is, though. There is. The judge says the agreement, the contract on its face, does not give Wayfarer the right to have JonesWorks or Jones follow any instructions it might give. So in the future, anyone who wants to do business with Stephanie Jones better pay real good attention to that, because she's apparently just going to go rogue on you and there's nothing you can do about it. I think her clients should have a good look at their contracts. Honestly, I just think this is really dumb. Again, I know it's personal feelings, but that is how I feel. I mean, even here it says Wayfarer does not allege how Jones' emails to the Sony execs violated her obligation to perform the services specified in the agreement in a professional manner. It does not identify any provision that gave it the right to demand she not take action to clear her name when she believed that such action was necessary. Okay, but taking the actions that she took, which were completely unreasonable, by the way, because she knew that this was going to make things messy and that she should stop because they warned her 1,000 times. Taking the action to clear her name, in my opinion, was not in accordance with the goals mutually established in the contract. But that's just me. So again, the dismissal on that count was granted. Now we have breach of the implied covenant of good faith and fair dealing. Wayfarer's third claim alleges a breach of the covenant of good faith and fair dealing. They allege JonesWorks and Jones engaged in conduct that prevented Wayfarer from receiving the benefits contemplated under the agreement, including by maliciously feeding its confidential information to hostile third parties for the specific purpose of harming Wayfarer and Baldoni, acting against Wayfarer's interests and otherwise depriving Wayfarer of the benefit of its bargain. Wayfarer alleges that in the wake of JonesWorks' termination of Abel and in the wake of Wayfarer's announcement that it would terminate its agreement with JonesWorks set out to injure its departing client. And my interpretation of this section is kind of like that. Even if you have a contract and you are technically following the contract, you can't also secretly sabotage the client or the other side of the deal and screw them over and undermine the whole point of the contract in the first place. So they were saying that JonesWorks worked against them and shared damaging information. and tried to hurt their reputation on purpose. And we get down to the question here, did the Jones party's conduct violate the covenant? The judge says it is plausible to infer that Wayfarer hired Jones Works to develop relationships with other media figures like Blake Lively, and that the sharing of negative information about Wayfarer with Lively would undermine the object of the agreement. He says the parties don't need to have an express agreement that she wouldn't share negative information to third parties about Wayfarer, and that there's no question that the actions Jones Works is accused of having taken would have been viewed as defeating the object of the services to be provided. So this claim that in kind of a plain English broad way is saying they sabotaged us, they sabotaged Wayfarer, is surviving. So that claim is not dismissed. And that is not the most thorough explanation of this whole section that I can give, but it is what I can give right now in the time that I have. So this last claim is defamation per se. Wayfarer alleges that Jones and Jones Works made one or more statements to Leslie Sloan, Blake Lively, Ryan Reynolds, saying that they retaliated against Lively with a smear campaign, and the Jones parties say that Wayfarer failed to state a claim for defamation because it doesn't allege falsity, the statement regarding a smear campaign is protected opinion, and Wayfarer has failed to allege actual malice. And I'm really not going to try to interpret all this choice of law stuff for you guys. You know I'm not the best person to do that, but he did decide to go with California law. And in California, defamation involves statements that are, false, harmful to Wayfarer's reputation, not protected by things like opinion or privilege. And they also kind of have to assess with this specific issue, is calling something a smear campaign a fact? Are they presenting it as a fact, or is it like opinion? Is it Jones Works' protected opinion that they were smearing Blake Lively, or are they presenting it as factual information that can be defamatory to Wayfarer Studios' reputation? So whether it's like a factual statement or a protected opinion statement, the judge says it can kind of go either way. Distinguishing fact from opinion can be difficult, and what constitutes a statement of fact in one context may be treated as a statement of opinion in another. And he talks a little bit about the word choice here. It says, so too with the use of the word smear or smear campaign. In common vernacular, it may be a hyperbolic way of responding that an accusation is untrue. I mean, we see that a lot, right, online. The victim of a false public campaign may respond she has been publicly smeared, or the victim of a smear campaign. In that context, the statement would not be understood as one of fact or to convey the existence of undisclosed facts. Then he says the term could also be understood, though, as a plan to discredit someone or something or to destroy a reputation by means of smears. So that's by slanderous or defamatory remark, an attempt to defame by slander. The statement may connote that the subject has intentionally executed an undisclosed plan to knowingly spread false and defamatory remarks about another for some impermissible purpose, which is what the Wayfarer parties say we're looking at. The complaint pleads facts that make it plausible that a jury could construe Jones' comments in the latter fashion. So the accusations and the facts that Wayfarer have laid out make it plausible that a jury might find that Jones made these statements about Wayfarer executing a smear campaign in a way that was defamatory. It says the statement could be understood to convey that Jones was in possession of some undisclosed underlying facts. Jones was Wayfarer's publicist. She would have been privy to Wayfarer's plans and to its actions. It was her job to understand and implement Wayfarer's public relations strategy. The statement that Jones made then, carries an indication that she has actual knowledge of what Wayfarer is doing, and it could be reasonably interpreted as a fact. The judge writes, a jury could determine whether, in fact, Wayfarer had executed a plan to destroy Lively's reputation and career by means of false and defamatory statements. Moreover, as alleged, Jones did not simply accuse Wayfarer of engaging in a campaign to destroy Lively's reputation through false statements. She allegedly told Sloan that Wayfarer undertook to discredit and destroy Lively's reputation because she had complained about sexual discrimination on the set of the film. That, too, is a statement that can be subject to the test of factual truth. Assuming that Wayfarer engaged in a secret campaign to spread false information about Lively to destroy her reputation, a jury could determine affirmatively whether it did so because she had complained about discrimination or for some other reason. So the context of this statement matters because of who said it, who they said it to, and in what situation. And at this stage, the judge doesn't decide who's right. The question is it plausible that what Jones said could be defamatory? And the answer is yes. Because it could reasonably be interpreted as a false factual accusation involving serious claims of retaliation and misconduct, the defamation claim is going to move forward. They're not going to throw out the defamation claim because it might be protected opinion or it might be a false factual statement. So he's basically saying this calling it a smear campaign. Jones calling this a smear campaign to Blake Lively. It's not automatically defamatory, but if she's presenting it to Blake Lively as if it's an actual fact that she has knowledge of, this is definitely what's happening, and it's false, that would be defamation on the part of Jones. So going back down to this conclusion, we saw the first 2 counts were dismissed with prejudice, meaning they cannot amend those claims, but counts 3 and 4, they will survive. So the defamation claim that we just talked about, that was number 4, that survives. And then number 3, breach of the implied covenant of good faith and fair dealing, where Wayfarer is basically saying that Stephanie Jones sabotaged them. All right, sorry I couldn't really go through the whole thing in depth, but I did the best that I could with the time that I had. So appreciate you guys for watching. Don't forget to like button for me. It helps me out a lot. And I'll see you next time. Bye.